Hello and welcome back to the Data Privacy Lawyer. My name is Funmi Owolabi. Today's review, we're going to be looking at some AI terms. So I started a series on the channel related to artificial intelligence. The name of this organization is TalentCards. Let's have a look quickly at the solutions. Okay, so Deskless training, reinforcement training, compliance training. Okay, so training. I see here the word student. Now, if you're brand new to my channel, there are a number of different federal privacy laws related to the processing of children's data. Now, I'm not sure what type of students they're alluding to. Is it adult students or children? But there's a federal privacy law associated with processing children's data, children under the age of 13. And then there's also laws that are associated with processing student information. Now, depending on what type of training this is, those would be questions that I would need to ask this organization if I was their counsel. But we're just going to look at their AI terms. This was last updated October 22nd, 2024. Now, I don't know the geography in which this offering or solution is being provided, but subsequent to this date, there have been AI legislations that have come out in different geographies that influence the usage of artificial intelligence and the responsibilities that organizations have when it comes to using or creating artificial intelligence. So that should be reviewed. We're now in 2026, so this is about a year and a half old. Given the fast-moving pace of artificial intelligence legislation and then also the updates that are made to different solutions, I am pretty sure that since 2024, this organization has made some type of update to the solutions they have, and those need to be reflected in these terms, especially if customers are going to be signing up for this in 2026. So I've already seen a number of words here that have jumped out to me that are privacy adjacent. One of the reasons it's valuable to have a privacy counsel review your AI terms is because in almost every instance that I personally have encountered, the features associated with the artificial intelligence have some implications on privacy. Now, the capacity or volume of the personal data associated with an artificial intelligence offered by an organization is going to vary based on the tool. Some tools are going to ingest more personal data than others. However, there are still obligations you have irrespective of whether or not you are a healthcare provider that has an AI tool, or if you are a SaaS solution that provides services to employees only. You still have obligations irrespective of the personal data that is ingested by your AI tool or processed as a result of your AI. We're looking at this from lots of different angles. Let's say, for example, I don't know this solution, but I can give you examples of what I think. In order for the students to access the solution for the student training, they may have to use their name, their email address, maybe the school that they go to. There may be information related to their student ID to be able to identify them, and the business has purchased an enterprise license. Now, I don't know, there's lots of different questions I have, but the reason why I mentioned that is because you need to not only look at the personal data associated with the license that you're obtaining from a supplier, but you also need to look at the data elements that could be ingested as a result of the input and how you've trained the AI. So there's two different considerations on the customer side. From the supplier side, you've got the considerations of how you've trained the AI, what type of restrictions you've put on the features that you're enabling to your customers, and how that impacts your own privacy program. What does your privacy program look as a result of the solutions that you offer? And what are you putting in place based on what geography requires of you? Okay, let's have a look at this. Customer is responsible for ensuring that customer and its authorized users' use of the AI services comply with the terms of the agreement generally and this appendix. So not only are we taking a look at these AI terms, there's also an additional agreement that could influence some of these terms. This is valuable because during the request for proposal period, suppliers generally will provide customers with lots of information about the solution that the customer is looking at. Because these are public facing, I can access this. I'm not a customer of this organization, but I can access this and I can review this. When a business is doing its due diligence, it's likely that whatever order form or solution they eventually sign up for is going to reference this document. So even prior to getting into a contract negotiation with a supplier, you have insights into what types of restrictions may be applicable to your solution. Now, this may not be the terms of use for you and your solution, but we see here that they reference an agreement. I don't know the specifics of what are in the agreement, but I presume that if the AI is an enabled feature based on your service, this is going to apply. If the solution that you're going to obtain has artificial intelligence, it may be valuable to review these terms of use to see if they align with your own privacy practices and your own AI practices. Now, these are distinct, and I'll explain why. They're distinct because artificial intelligence touches on different types of legal questions outside of privacy. Now, privacy is a piece of it, but I think as more and more organizations are deciding to use artificial intelligence tool, there are policies that are separate outside of your regular privacy documentation that touches on all of the legal factors that make up how artificial intelligence is rolled out within your organization. Now, there are themes that are going to be recurrent amongst the privacy documentation and the AI documentation that you as the customer need to be reviewing. But essentially, I've just gone off on this long tangent to state, review your agreements and review this appendix during the request for proposal period if you have the opportunity to view it on a public-facing platform like the website, because it could influence the solution. And you should do that prior to the contract negotiation. Sometimes organizations are placing these terms and conditions on the website because they don't accept something called redlines. Now, if you're not in the legal field, a redline basically is, if you're signing up for a contract, any type of contract, redlines allow the customer and the supplier or whoever are the parties in a negotiation for a contract, it allows them to make edits to provisions that they cannot accept or make tweaks or clarifications to certain words. Now, let's just say this word, permissible. How many people that are not in the legal field understand what this means in the context of this provision? When I'm talking about red lines, I'm talking about how do each of these sentences interact with one another and how do they influence the solution that a customer is taking on? And can a customer accept each of these provisions? Sometimes you're not allowed to do red lines because it's being placed on the website and it's a take it or leave it. Sometimes the supplier is going to allow you to download a copy of this and have your legal counsel address any of the sections that are not applicable to your use of the solution or is not something you can accept based on your own risk tolerance. Now, that all really depends. I still think it's valuable to review these features because there is an impact on artificial intelligence as it pertains to privacy. And I saw something very interesting. Consent. Now, we've talked a lot. If you've watched any of the privacy reviews that I've done privacy policy reviews, I've done privacy notice reviews. Consent is a very specific word in the data protection space, and there are very specific factors that constitute consent in certain geographies. Some of those factors are consent must be freely given. Consent must be unambiguous. Consent must also be as easy to withdraw as it was given. So essentially, consent is a very unique word, and businesses need to be careful if they're going to be using it in their terms to understand the implications on a customer and on themselves too. I talk about this because from a privacy standpoint, now I haven't reviewed the agreement in and of itself, but I think it would be valuable to see what the agreement states constitutes consent. It would also be valuable to know where this supplier provides its solutions, because this means something very specific in the European Union. And if the customer is in the European Union or is providing European Union personal data, then this is going to have specific implications on both parties, and they both need to be able to understand what that means. So I really hope you enjoyed this review. If you have any questions or comments about my understanding of this terms and conditions, leave a comment below and I'll see you in another review.